Welcome back to online classes. Dear students, how are you? I'm James here. Dear viewers, today topic is Indian Penal Code under section 329. What is that 329? Let's see. Voluntarily causing grievous hurt to extort property, extort, extort property, or to constrain to an illegal act. Voluntarily causing grievous hurt to extort property or to constrain to an illegal act. Section 329 explain about whoever voluntarily causes grievous hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any property or valuable security, or of constraining the sufferer or any person interested in such constraining sufferer to do anything that is illegal, or which may facilitate the commission of an offence, shall be punished with imprisonment of for life. Life means life imprisonment up to death. Imprisonment of either description for a term which may extend it to 10 years, and shall also liable to fine also. So the section is similar to section 327 of IPC. The only difference between that, the hurt caused under it is grievous. Where grievous hurt was caused to obstruct the person from deposing in court, the court said that it amounted to forcing him to commit an act which was illegal. At the time of framing of charge, under this section was not improper. In this provision, the words "for the purpose of extorting" are most important to meet the argument of learned counsel for appellant of any other appeal. This will include an attempt to extort also. This provision would be attracted even if extortion is not complete. Section 329 of IPC deals with grievous hurt caused for the particular purpose, that is extortion or other purposes mentioned in this section. The offence of extortion may or may not have been completed. Two appellants along with others attacked the complainant with knives. The two appellants with one more each stabbed the complainant. In this situation, what happened? They were held liable for each other's acts because they acted in concert to extort money. This is what explaining about this section 329. Students, will discuss with another section because all the above sections are related to one by one only, but length of the imprisonment is entirely different based on this offense. We'll go to section 330 of IPC. It explain about 330 explain about voluntarily causing hurt to extort confession statement. Voluntarily causing hurt to extort confession. If any one of the person to extort the opposite person to give, to taking confession from the any statements voluntarily. Why? Because he wants to collecting from any other matter from the particular person. That is voluntarily causing hurt to extort confession or to compel restoration of property. So in this section 330 explain about whoever voluntarily causes hurt for the purpose of extorting from the sufferer Okay, sufferer means victim party, or from any person interested in the sufferer, any confession or any information which may lead to the deduction of an offense or misconduct, or for the purpose of constraining the sufferer or any person interested in the sufferer to restore or to cause the restoration of any property or valuable security, or to satisfy any claim or demand, or to give information which may lead to the restoration of any property or valuable security. So, above situation, the person shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable with the fine. Okay, I will give you illustration based on this section. We have 3 illustration. Number 1, here A is a person. Okay, I will take A is it. 2 person is available. A police officer. Okay, A is a person. He is a police officer. Tortures is it. Is here another person in order to induce is it to confess that he committed a crime. What happened here? A is a police officer. A is a guilty of an offense under this section. What section? Section 330. Okay. Second illustration. Same, A and B is available in this illustration. Here A is a police officer, tortures B to induces him to point out where certain stolen property is deposited. Okay, now A is guilty of an offense under this section. And third illustration based on this section 330. In this illustration, A is at 2 person is available. Here A is a revenue officer, tortures Z person. Z in order to compel him to pay certain arrears of revenue due from Z. Now A is guilty of an offense under this section. Okay, now it's clear, students. Okay, another illustration also available. I will give you. A is a zamindar. Is the zamindar tortures a riyat tax, no? Riyat in order to compel him to pay his rent. Now A is guilty of an offense under this section. Okay, I will give you small comments about this section. This 328 section is similar to section 327. Okay, which deals with causing of hurt for the purpose of extorting property or valuable security. Extorting property or valuable security. Okay, it punishes the inducing of a person by causing hurt to make a statement or a confession having reference to an offense or misconduct, and whether that offense or misconduct has been committed is wholly immaterial. Okay, and another thing, an offense under this section is made out if it is proved that the accused caused hurt to extort confession or any information. If the victim dies later, it is not necessary to prove that death was a result of the hurt caused. The offense is complete as soon as the hurt is caused to extort confession or any information. Okay, I'll give you another example of this section. Custodial torture. How the custodial torture was going as per the IPC. Okay, though section 330 of IPC and section 331 of the Indian Penal Code make punishable those persons who cause act for the purpose of extorting the confession by making the offence punishable with sentence up to 10 years of imprisonment, but the convictions as experience shows from track record have been very few compared to the considerable increase of such onslaught, because the atrocities within the precincts of the police station are often left without much traces or any ocular or other direct evidence to prove as to who the offenders are. Disturbed by this section and then distributed by the situation, the Law Commission in its 113th report recommended amendments to the Indian Evidence Act 1872 so as to provide that the prosecution of a police officer for an alleged offence of having caused bodily injuries to a person while in police custody, if there is evidence that the injury was caused during the period when the person was in the police custody, the court may presume that the injury was caused by police officer having the custody of that person during the period, unless the police officer proves the contrary. Okay, based on this evidence set, the onus to prove, onus, that means burden of proofs, onus to prove the contrary must be discharged by the police official concerned, keeping in view the dehumanizing aspect of the crime, the flagrant violation of the fundamental rights of the victim of the crime, and the growing rise in the crimes of this type, where only a few come to light and others don't. The government and the legislature must give serious thought to the recommendation of the Law Commission and bring about appropriate changes in the law, not only to curb the custodial crime but also to see that custodial crime does not go unpunished. Okay, the courts are also required to have a change in their outlook, approach, appreciation and attitude, particularly in cases involving custodial crimes, and they should exhibit more sensitivity and adopt a realistic rather than a narrow technical approach while dealing with the cases of custodial crime, so that as far as the possible within the powers the truth is found and guilty should not escape, so that the victim of the crime has the satisfaction that ultimately the majesty of law has prevailed. Okay, since the cause of death has been shown to be asphyxia on account of detention of the deceased in unhygienic conditions despite his respiratory problems, and the injuries to the ribs and mouth of the deceased could possibly have been caused by the attempts made by the doctor at the hospital to resuscitate the deceased, who had been brought to the hospital in a comatose condition, coma stage, with the body showing no signs of pulse or respiration or blood pressure also. This is a prima facie as a case is made out for framing of charges. This framing of charges under section 330 of Indian Penal Code. Okay, what happened? And another thing, and his family members were brutally tortured by police officials. It is said that order framing charge against petitioner is proper. Okay, another example, conviction under section 302 330 and 34 based on unsigned DD. What does that mean? Conviction. This is another example of this same section. Here, conviction under section 302, 330 and 34 of Indian Penal Code based on unsigned DD. What is that? Here, death caused by police officers to extract confession based on dying declaration. At the time of dying, any one of the person declaring is a statement before the doctor. Okay, before the doctor only validity of the dying declaration. If it is the dying declaration before the police officials, is invalid. Okay, but before the producing at the time of producing magistrate, in presence of police and in presence of medical doctor also, the dying declaration is valid as per the Evidence Act. Okay, so the guidelines issued by the Delhi High Court that the declaration should carry the signature of the declarant not observed, so held that the issuance of the guidelines is for ensuring and for testing the genuineness of the dying declaration of person who is in last moment of his life, merely because there was a defect in following the said guidelines. Okay, which as is now pointed out is of a trivial nature, and if the dying declaration recorded is otherwise proved by ample evidence, both oral evidence as well as documentary, on the ground of such trivial defects, the whole of the dying declaration cannot be thrown out by the reason of such trivial defects. Okay, this was saying difference between this conviction 302, 330 and 34. 34 means the 34 IPC is saying that common intention. Okay, 302 is punishment of murder, and 330 explain about voluntarily causing it to extort confession or to compel restoration of property. Okay, okay students, I am closing this session. I will discuss another section with another video call. Okay, enjoy with video lessons and send me your feedback. Subscribe. Those who are not subscribed, subscribe immediately. Okay, enjoy all video classes. Don't worry regarding about your legal subjects. Okay, enjoy with your legal mind also. All the best. Thank you. Bye.